And we are recording, so let's get started. One of the things that you will see me distracted a little bit as we get started here in the first 5 or 10 minutes is often people are coming on after we start. Because of the security issues with Zoom, people end up in a waiting room and have to be admitted. So I'm splitting my side of view here between people in the waiting room and the presentation, but it shouldn't last very long. We should have mostly everybody on in the first 10 minutes. Joan, I want to really thank you for coming on and your interest, not just in the topic, but really your interest in being business savvy. Whether you are thinking about employment or are currently in employment and want to think about possible negotiations down the road, we really applaud you for taking that opportunity to sort of, I would call it, professionalize who we are as midwives. And many of you who follow me know that I really feel strongly that until we can stand strong and feel as though we have a right to negotiate employment arrangements, most professionals in our organization are underpaid and have many less benefits than our counterparts in other advanced practice roles. So tonight specifically, we're going to talk about covenants not to compete, also known as non-competes. And we want to make very sure, and I told Joe that I would read these, that you know that while Joe is a licensed attorney in Kansas and Missouri, he cannot act in a representative capacity for any of you on the seminar, that we're sharing the information in an effort to provide scholastic conversation, not legal advice. And there's no intention on the part of either of us to create any kind of formal client relationship or attorney relationship through what we say or the supporting references that we'll be providing at the end. So what are the objectives that we decided could be valuable to the audience? First of all, in our working with a lot of midwives and contract review, there is a general lack of complete understanding of non-compete laws and whether they're sort of laissez-faire or they really can be enforced, particularly in the health professions. And I'll show you a fascinating survey that I discovered about health professionals' understanding. We want to specifically talk about a case in 2019, which was high profiled, involving 4 nurse midwives and 3 women's health nurse practitioners who worked for a single obstetrician in Texas and were forced by injunction to cease their practice after the termination of their employment. It's an interesting case and one that really will resonate with why this is important for you to understand. We're going to share with you 4 examples of non-compete clauses that we have reviewed. We've modified them to not disclose who the client or the employer was, but to use them as examples of how non-competes can vary in language and in content and sometimes in hidden or non-hidden expectations. And then we want to end with some strategies on how to modify or negotiate out of non-compete clauses. So that's our general take for tonight, and we hope this will be helpful for you. It's important to have just a general definition of what we're talking about. And so non-competes, or covenants not to compete, really exist in the post-employment context. And usually they show up as a list of covenants towards the end of a contract. Think of the logical flow of how contracts are formed. Most of them are templates. And usually you see these clauses towards the end of a contract. And they will state, and we're going to talk about this more than once so that hopefully at the end of this presentation, you too can share with your friends the 3 things that non-competes address. They address the fact that the employee must refrain from accepting employment in a similar line of work for a specific period of time in a certain geographic area. And those three characteristics will always be found, or should be found, in non-competes. So why is it so complicated? Well, non-competes are characterized in the lit review that I did, and Joe will talk about, by intersecting legal elements of contract law, employment law, antitrust law, where we'll talk about the Federal Trade Commission's new effort at the federal level from an antitrust viewpoint to end non-competes, and the fact that enforceability of non-competes vary widely in state law. So there are not uniform laws, just like there are not uniform laws about scope of practice of our profession in midwifery. And it's interesting to note that California, Montana, North Dakota, and Oklahoma are the 4 states that ban non-compete agreements for employees, or prohibit all non-compete agreements except in very limited circumstances. And we're not going to go into that tonight, but I'll show you a reference that you can look up state by state laws. So let's talk a little bit about the balcony view of health professions. The American Medical Society has a very strong position and are petitioning specifically against the Federal Trade Commission's efforts to end non-compete agreements in the workplace. In essence, they believe that physician non-competes have a useful purpose and that each state should just be left to their own decision-making on how they want to regulate the contracts. And when that came out in early February of this year, there was a lot of pushback by physicians who actually aren't members of the American Medical Association. And what's fascinating about the power of the AMA is that they wield their organizational title quite aggressively, especially against nurse midwives and other types of midwives across the country, saying they represent physicians, but in reality, they represent about 25% of all physicians in the country, and that many of the physicians had widely different perspectives than what the AMA was saying to the Federal Trade Commission. So they clarified their policies on post-employment and non-competes in an ethical opinion statement, which you can find, it's cited here. And they also added, since COVID-19, that this should be a reason to not enforce non-competes. Now that's interesting because we've actually had some people contact us about the enforceability of non-competes during COVID. And it's important to note that even though this is not a midwife position, it is a health professions position that could have some weight in these conversations if they're part of what you're thinking about. So what about non-physician providers? It was interesting to note that the American Nurses Association, the American Association of Nurse Practitioners, the American College of Nurse Midwives, and the American Association of Nurse Anesthetists, out of all those groups, which represent the majority of advanced practice professions in our country, in my lit review, which probably wasn't, a PRISM scientific method, but a pretty good deep dive in scholarly articles in the last 5 years, the only organization that had queried their membership is the American Association of Nurse Anesthetists. So what did they find out? They surveyed in 2015 all of the CRNAs and student RNAs in the nation. They had 242 practicing CRNAs who responded, and of that group, almost 61% were employed without a non-compete clause. If Joe and I compared that to the statistics of the non-competes we're looking at in the contracts we review, I would say that 60% or more, and Joe can follow up on this, are requiring nurse midwives and midwives to have non-compete clauses in at least the original contracts we're looking at. So what about the knowledge level of the nurse anesthetist? Their knowledge level about non-compete clauses was the lowest on the Likert scale that they could have scored by average of 55%. So what that tells me is a couple things. We need to look at other professions, not only when we think about salary, when we think about work hours, when we think about overtime, but we also need to think about our peers in terms of non-competes. Why is it that of that small sample, almost 61% were employed without a non-compete, yet in the midwife world, it seems to be flipped? So I'm going to turn it over to Joe, and we'll talk a little bit more about the specifics.
The enforcement of non-competes is really a matter of contract law. And when we have a yes and no here, we're talking about situations in which the government, either usually through legislative caveat or through case law, meaning different decisions were made by courts that were later never countermanded by the legislature, to decide a balance not only between the interests of the two parties engaged in a non-compete agreement, the employer and the employee, but also the public interest that's involved. And the public interest is a major issue, as we talked about with COVID, and we talked about with just simply access to people who can deliver babies, those sorts of things. When you have two physicians in a community that really needs at least two, if not three, and one of them managed to hire the other one and now wants to oust the lesser powerful physician, you wind up with a situation where the court may say, we're not going to enforce this whole agreement because we need two physicians in town. The public interest outweighs the interest of the individual. Through that process, a lot of legislative attempts have come about to try to resolve that. You'll see a link below, and I believe what that link's going to do is lead you to a series of places where you could look to see whether or not non-competes are more or less involved in physician care and can be extrapolated to some extent to midwifery care. On this slide. We'll go to the next slide. We want to talk, we've alluded to before, but there's this lawsuit that happened in Texas. And according to the lawsuit filed originally, 7 RNPs who worked at a privately owned practice in Longview, Texas, were handed letters of termination by the owner, Dr. Z. And they were asked to sign a new contract, which if they wished to continue working for him, they had to agree to the non-compete. This goes to one of the first places that we're talking about, and that is the idea of consideration for a non-compete and whether you're forced into a non-compete from where you already work with somebody or not. So let's take a deeper look and go to the next slide. This particular non-compete, and we'll talk about non-competes and dissect a few here in just a few minutes, but this particular one said the following, and that is that when they left the termination of the employment, then the employer will not engage in providing women's health services, including OBGYN services, either directly or indirectly, actively or silently, etc., for 1 year and then listed specific entities: Circle of Care, Wellness Point, Diagnostic Clinic of Longview, Trinity Clinic, or its successors, or within 20 miles radius of the employee primary clinic known as ZED Women's Healthcare. So if you read through, we pulled the briefs that were part of one of the appeals that went up, and you wind up with the situation where this particular provider, Dr. Zed, had, how do I want to phrase it, had started to have a bleed of midwives. They lost 2 or 3 directly to other competitors. And so this was the dirty list that they had of people they thought were going to take it. There was another, a federally qualified healthcare provider that more fit within the 20-mile radius of employer's location. It and the midwives got sued to stop competition. Let's go to the next one. So litigation began, and the problem that we have is, as you can see, it became quite involved. So one of the first things that you have is, what is the right of redress of somebody if they feel like they're aggrieved because the employee has now violated the non-compete? Well, one of the most common and first things they have is a right to have an injunctive relief. And what that means is they can go without having a hearing, make their allegation that the employee is violating the non-compete. The court will look at the non-compete and make an order that says, if you're violating the words of this non-compete, stop right now or you'll be in contempt of court. And so that's what happened to these people. They were effectively shut down. They moved from one job to the other. They felt they had good reasons why they could move from one job to the other and be right. But then the court's injunctive relief, before you even try whether or not these factors are okay, was employed. And the appeal, there were 2 sets of appeals. The appeal ran up to the Court of Appeals when the court issued the injunctive relief, and then they went to the Court of Appeals, the next step up in Texas. In Texas, you have a district court, Court of Appeals, and then the Supreme Court of Texas, and tried to fight the non-compete. Considerations in this argument were, first of all, the midwives complained that they were forced to sign this non-compete. They had been working there for years, one of them 4.5 years. And in this process of signing this non-compete, they were basically told, you're out of a job unless you sign this. And so the first question was, and we'll get to this in detail, was there any consideration? In other words, did they get anything out of the deal, or were they just coerced into it? And the conversations went to a ridiculous level, including the fact that they got to use the practice's electronic medical record system. The practice let them use their computers. They got to keep their job, those sorts of things. So there was no big hoorah over changing from a situation where they were employed, where they could work, they could quit, and they'd go work anywhere else, to this new situation. And one of the answers by Dr. Zed's attorneys was, that doesn't matter to get the injunction to keep you from working. That matters if you decide you're going to win at the eventual trial. Also built into this particular contract set was a provision that whoever wins pays all attorney fees. Now, I do appellate law for a living, and mostly in the family law circle. Appeals usually cost somewhere between $10,000 and $50,000. So you not only have a group of attorneys who are working for Dr. Zed, but you have a group of attorneys who have now done 2 appeals. So the legal costs alone create you just can't let go of this situation, because you either have to win or cut a settlement or move on. As is noted here, you can imagine the kind of stress these people went through, the kind of professional embarrassment, and probably the loss of opportunity that they experienced. Next slide. So eventually what happened, apparently, according to one party, SHRT is a federally qualified healthcare provider, in other words, the competitive employer, and not necessarily the individual midwives or advanced practice nurses says that they managed to resolve amicably all of the issues. Now, one of the things that happened was that happened almost after the full duration of the period for the non-compete. So these people were, instead of being able to try their issue of whether or not they were right or wrong, lived under this injunctive or temporary order relief, which went on appeal, and fought that through this rigorous process and expensive process to have a settlement at the end for whatever that settlement meant. Often settlements are confidential in nature, and so you don't know what the terms of the settlement were, but you wind up with this Dr. Zed winning on a practical level, even if he had no right to win on a ethical or legal level. Next slide. There are 4 fundamental elements to evaluating the non-compete. The first is consideration. That means that, do you get anything for having sacrificed this incredible opportunity to be able to stay and work in your community? When we advise people about whether they should consider a non-compete, one of the things we relate to them is the incredible cost that it may have. Many of these non-competes involve almost necessarily that you leave your community. That might be fun if you're a new graduate that comes out, but if you're a new graduate over the term of the contract, say 4 or 5 years, turns around and finds true love, has a couple kids, and everybody's mired into the community and their professional expertise has moved on, well, that should be worth something. And often consideration, the first layer of consideration is, if you're willing to take the job, and we'll look into the details of how these look, if you're willing to take the job, that's consideration enough, that you made this deal, that you took this wonderful job opportunity, and part of that job opportunity was to sign this document. And so you go back when we look at contract reviews, and Ginger, I don't know whether it's expecting a space bar or why it isn't automatically moving forward. If you go back and look at these contract reviews that we have, many of these contracts aren't that special in the first place. But we look to the consideration, what do you get for having signed one of these? And then we evaluate it on those 3 factors that Ginger mentioned before. And those are the duration of the restricted period, the scope of prohibited activities, and the geographic limits imposed. So let's take a look at 1 or 2 of these contracts that have been around in our files. So just 1 second here, pulling up a tool. Oh, I can't. I was going to give the laser. It's not my PowerPoint slide. The first section is this statement that appears senseless, but is the consideration statement as a material inducement for the practice to enter into this agreement. The APN, meaning midwife, let's put that word in there, agrees that during the term for the period following, meaning this contract says that you're agreeing, if you sign this agreement, that you're just fine having no additional incentive other than what's within the 4 corners of this contract to be paid your just dues for agreeing not to compete. Then we have a duration factor for the period of 1 year following the termination of this agreement for any reason. And then they go back and call that the restricted period. So they're saying that whatever these provisions are, you can't do it for 1 year. We often look at these things and say, what does 1 year mean? If you're trying to keep people from robbing people who are current patients who are going to deliver babies, 1 year is probably twice as long as you need. And then we have the scope of the practice. Midwife, I'll substitute, shall not, without prior written consent of the practice, engage in the practice of obstetrics and or gynecology related medicine or surgery within the restricted area as defined below for the midwife or on behalf of any person or entity or other practice or have an ownership interest, debt, or contractual relationship directly or indirectly with any entity or individual which owns or practices as a healthcare provider. So basically you're saying that for 1 year, you won't really have anything to do with what you're trained to do, or you won't even work in an entity where you help people do that. And you won't work with an entity who is serving it and you're serving in any other capacity. So two respective birth centers are across the street from each other, and you're a midwife, and you decide to leave practicing as a midwife, and you want to go over and become a janitor at the other midwifery practice that's across the street. You're prohibited from doing it. It's so broadly cut that you can't, whatever you do. So the restricted area then is a geographic issue. And that is within 10-mile radius of any office utilized by the practice where you perform services. So you may begin practicing with somebody who has just one location, but let's see what happens if they turn around and develop one or two other other locations, whether they be hospital services that you migrate to as you go through this process of collaborative practice or whatever it is. Then you begin to see how 10 miles could turn into the entirety of a community based upon this language. What is nice about this particular agreement is it mitigates that broad sweep and say that this has to be more than 10% of your practice. So if you had a midwifery practice in a birth center and they had frequent interaction with and participation with the local hospital, but infrequent with another hospital, the 10 miles might be two Venn diagrams or circles that you would have, but around the practice itself and around the hospital. But those infrequently dealt with over the previous year would not be involved. You can see how this language begins to sculpt an anger. So here's another one, scope. It's a 1 year period of time. It's limited, and this one is one we liked better because it's other than termination without cause. We think it's completely unfair to have a non-compete pressed upon you when the initial motivation for having a non-compete is that you won't rob patients from the birth center, practice, whatever you're working for. But what happens if they hire you and 60 days later they decide that they just don't have the patient draw to keep you? This agreement provides that if they just fire you because they can't afford you anymore, or just don't like you, or don't like the color car you drive, this non-compete doesn't work. But if you quit yourself, it would. Then it goes on, again, without prior written consent, any of the activities dealt in another section, which we didn't include with this, and a 10-mile radius from the practice location, and names it specifically. So this is a better non-compete than many non-competes in the sense of it serves the purpose intended. The employer does not want somebody moving within 10 miles of them and competing with them if they've been fired because they were a horrible employee and they were fired for cause, or if they quit on their own, but this employer is not pressing these non-compete restrictions if they simply decide to call it quits on the relationship. And our feeling is that, the whole purpose and understanding of what a non-compete might be is that we're not going to rob the employees or rob the patients from the practice. That's a quid pro quo. Don't fire me and expect me to do something different. Remedy solutions are very interesting. We'll go through another one that has unbelievable remedy restrictions, but this one says that they can get this one is one of the unbelievable. If you quit and you move across the street and violate this non-compete, this particular agreement was starkly unusual in the sense that it had a liquidated damage clause of $50,000. So if you made $100,000 a year, you're going to net 60. If within 1 year of doing that, you decide you're going to leave and go across the street and start your own birth center and violate this non-compete, among other damages that are often found within other parts of the contract, you owe $50,000 post-tax money. That means that you probably would make for that year in your own employment somewhere around $10,000 or $15,000. On top of that, you're very likely to owe tail coverage, other things. So it could be an economic disaster to enter into and especially breach this agreement. So here's a new one. With the exception of duties that you perform for employer on behalf of pursuant to this agreement, you agree that during the term of 2 years, so it's a longer period of time, or termination of the agreement for any reason whatsoever. In other words, you sign on to be an employee of this practice, and they have you there for the initial period that's sort of like a trial period, and they decide it's just not a good fit, you're still unable to compete under these terms for 2 years, even if they fired you just because they got tired of talking to you. And it's a 15-mile radius from any practice location of employer where you provided services during the term on behalf of the employer, engaging in services or engage in any business or perform any services. Well, these are the restrictions. So what you have here is 15 miles from any time you worked anywhere because they told you to go there. So you can't predict what that 15-mile radius is until you know what services you performed where. You can imagine that if you had a combination of hospital, birth center, and maybe even home deliveries, how much of a catchment area you could have. And you would very likely have to move under that scenario in order to have employment. Here's a new one. The consideration clause is you're in a position of trust. You will have a personal contact and will develop personal relationships with patients. In order to protect the relationships the center has with its referral and its patients and to protect the center's confidential business information. So that whole thing right in there, that all the way down to plans, comma, is a way in which the author of this contract says this is what consideration is given for you agreeing to enter into this contract. Then it's a 2-year after the end of employment, and a 50, within a 50, and is inarticulately written, this particular contract says within a 10-mile radius, meaning they didn't write it correctly. We suggested amendment on that, of the center's places of business. So if they have, just call it 10 miles, if they have 3 locations inside a community to provide any kind of business or service. So if they, in theory, if they had a business office, a practice, a business office 10 miles away from the practice, those 2 circles would cover no less than a 20-mile breadth. And you agree not to provide or solicit. And this is the problem with solicit. You're agreeing not to solicit. So are they saying, and many of these contracts are really even closer, are they saying that your billboard can be seen from 10-mile radius? So you're soliciting within that 10-mile radius. It's wildly broad. And for the purpose of this restriction, solicit to provide includes, and like I said, advertisements, communications, or others. So if your email blast or your TV, your practice's TV advertisement invades this 10-mile radius. So in other words, this 10-mile radius is utterly meaningless. They're saying you cannot work in the community. And then
what's important to note in this one is this is specific to childbirth related services outside a hospital. So this is a birth center contract that does not infer they couldn't go work in the hospital. I just wanted to make sure you saw that.
That's true.
But it's still not good.
Oh yeah, it's still outrageous. So the center can ensure itself you're abiding by this non-competition. You agree to a 2-year period following the end of your employment. And then this is what we consider horribly offensive. You will provide a copy of this agreement to every person and entity for whom you propose to work. So how do you move from a midwifery position where you are making $100,000 a year and you're marketing yourself saying you're worth $175,000 a year, but still be required to provide a copy of this agreement? To which the new employer goes, well, why are you worth more than you were in the job you're working? Among several other privacy issues. And then you also have to turn around and tell the practice, anytime you're offering yourself out for employment, and give them notice so that they have an opportunity to sue the potential employer if they believe that it's violating their non-compete. But you're basically saying you're working day after day in an employment relationship where they can fire you without cause, and you have to tell them you're out looking for another job, which means they'll turn around and fire you the minute they know you're looking for another job, and you're completely wiped out for the entire community under this scenario. The way these courts enforce these agreements is widely different, and it's totally unpredictable for the midwifery world. We know the base case law, as I mentioned before, is built around this idea that you will be providing, that physician services can be such a higher priority, such a higher public interest, that the community is not going to restrict these covenants for that kind of service. What is not clear is how respected midwifery services are in answering this call for mother-child services in communities that are not well served, rural communities, etc. And which wind up with is what I refer to is, what did the judge eat for breakfast this morning? Is one judge on one day may say, there's nobody catching babies here except for you two, and you two are busier than anything else, so I'm not going to enforce this, or I'm going to modify it in an important way. Another day, the judge may look to it as, this is a contract, I respect contracts, and I'm going to enforce the contract. So what case law has developed internationally, but especially within the United States, is they can modify or amend the agreement's terms, the judge can, to fit the circumstances and answer these social policy questions otherwise. And they include the employee's right to have a meaningful opportunity to make a living, and whether the employer is having a reasonable risk of concern. You'll note back, many of these considerations in the contract are basically you develop confidential information for the client about the clients. You understand trade secrets, and I don't know about you guys, you know better than I, but birth and babies doesn't include a whole lot of trade secrets, and other issues that would be different from a non-compete in other contexts. One place where non-competes are pretty well enforced by the nature of their terms is when a small business person sells their business. And let's just call that Joe's Barbecue. And I'm Joe, and I want to sell it to Ginger. One of the last things Ginger wants is for Joe to wake up the next morning, walk across the street, and start selling Joe's other barbecue, because all the customers are just simply going to migrate over there, and they'll just think it moved across the street. So the courts are going to enforce Ginger's non-compete agreement as part of the consideration for paying whatever she paid for the Joe's barbecue, because part of the deal was that you wouldn't turn around and spoil the whole deal. Well, midwifery services within the context of another of a practice are very different from that. And people need OBGYN care and midwifery services across the spectrum, across the life cycle, and none of these may be in competition with one another. So the court looks, and it may tinker with the length of time that the covenant is effective. In other words, it might issue its injunctive order hearing and say, I'm going to put it to 6 months. It may change the geographic restrictions because it found that you wind up with these bubbles across the community that effectively means that nobody in the community can have the services that the discharged employee midwife is willing to offer, to the detriment of the community. And then the scope of related activities. So as Ginger mentioned in one of these, the non-compete was horrific, but it only dealt with offering birth center services. If you wanted to turn around and be hired by a hospital, perform the same services, a full scope midwifery for an institution like a hospital, the non-compete was ineffective. So the court could put that kind of amendment to the restriction and change the restriction in that way. But again, the biggest problem is this comes up, and this dialogue comes up after the court has issued at least some level of injunctive relief, and depending upon when the judge is going to hold a hearing on what to do about that later, the injunction is on the strict terms of the agreement, and is very unlikely, because the other side isn't there to argue it, to modify that agreement and trim it down. So you move, you think you're in compliance, an injunction is issued that says you can't work there anymore. Your employer has to say, we can't have you work with us, or we can't have you do this or that. And this litigation could go on for quite some time. So they're very, very dangerous, even if they're poorly written. Next. Ginger's going to take over on this part. You're muted, Ginger.
What we want to leave you with are some thoughts before we get into a Q&A with you. First of all, having taught in midwifery education for about 17 years in 2 different programs, I'm aware of the limited nature of how much student midwives learn about business. And so I would say, don't take this harshly, but most of the midwives we work with in reviewing their contracts have no idea of the brevity of what this one clause, among many other restrictive covenants, could cast on their professional opportunities at some point in time. So we wanted to provide you with 10 ways to consider if you're faced with a new employment agreement or an opportunity to rediscuss your contract in a year or every 2 years of negotiating some of these restrictive covenants. So first of all, you need to understand what the contract is asking you to agree to. And you can see just by the 5 examples, the Texas case, as well as the 4 we provided you, that either by intentional design or not, they're typically not written in layman's language so that we can decipher them. But it's really important that you understand the 4 areas that Joe outlined: the consideration, the geographic region, by exact address and timing and scope. We would suggest that if you are discussing a non-compete that exists or that is restrictive, that you be able to have a conversation about the fact that you're not a competing provider. If it's a physician employer, and those are typically where the non-competes come from. Hospital-based practices that employ midwives tend to not have non-competes. So your scope is vastly different, your authority is vastly different, and you are certainly a lower wage worker. So the consequences of what happened to the Texas midwives, or to any midwife put in a situation where an injunction has happened, or they're not allowed to practice in a community where they've grown up, is significant. And telling the story about that can sometimes be a way of opening the door to, okay, maybe this was a template. It wasn't my intention. We've actually come across contracts where the midwives discovered through our help that something existed. They took it back to the obstetrician and he said, oh my gosh, I didn't know the lawyer put that in there. I don't want to do that. And they may have gone ahead and signed it with him not intending, but it was there. So the story is really important. And that means asking why the non-compete is important.
I'd like
I think,
just
go ahead, Joe.
People employ lawyers sometimes under vague context, and somebody says, can you give me a good employment agreement? Or they even download it off the internet, for God's sakes. And that's the question. And so the employer, who may be very busy, may have no clue of what the legal considerations are, thinks that they came up with a standard employment agreement. And what you find when you go to negotiate with them is those aren't anything that were really important considerations to them either. So we try to caution people when we say, this is one of the most horrible agreements we've ever read. That doesn't mean you're dealing with one of the most horrible people you ever dealt with. It means that the agreement has cast shade in every way possible to benefit the employer. And the employer, again, may have no idea what that says. I've just recently met with a physician who was working on trusts and wills and didn't understand a single thing that we were talking about because they went to med school. And so they just simply trusted whatever I wrote down and said, if this is the way it works, this is what I want to do. So going back in and having a conversation that's heartfelt and open-minded is very important in negotiating.
Yeah, and I would say it casts the beginning of a relationship of trust. To be able to have that kind of conversation brings you in as a provider with vested interest. That you're not doing it in a defensive way, but in an inquisitive way, sharing the health provider shortage that we know exists in women's health care nationwide. Mentioning that many states do not enforce or allow non-competes, that many non-physician providers, such as nurse anesthetists, are not held to non-competes, that most physicians in our country do not support non-competes. A lot of times, the physicians are simply not aware. And I think if we're too afraid to have a conversation about many issues of the contract, with this just being one of many issues, then you become sort of in that default role of I'm the nurse, I'm the servant, I'm going to do what you tell me to do, and I'm going to blindly trust you. And we're trying to move people out of that to a higher level of collegiality. We would suggest that you ask for more reasonable conditions, such as within 10 miles of one named address for 6 months after termination. So really putting it, if they're not willing to remove a non-compete clause, within something that's a much more reasonable, manageable, clearly articulated set of conditions. Another option is that it's only enforced if you become an independently practicing self-employed midwife in the community. So you would be in potentially direct competition, although completely different scope and income generation. That's another consideration, and definitely we recommend that it not be enforced if fired without cause. Another strategy is to consider negotiating out of one or two of the three elements. So maybe you can just get them to move on the miles, which is what happened on the contract we saw a minute ago that actually had a red line through it that didn't transfer when I copy and pasted. It went from a 50-mile in their negotiations to a 10-mile radius. Or maybe you can negotiate the length of time, which is one that's commonly successfully negotiated from what we've learned. What happens if you are simply unwilling to sign? And the non-compete is the only clause keeping you from doing that. The rest of the contract looks good. You feel like you've made some concessions on your part. We know you can't get everything in negotiations. You've done your best. But when it comes down to the brevity of the of the non-compete, it would simply not allow you to practice in your community from which you're not going to move from. What happens? I mean, and you need to be ready to be able to discuss if it's a deal breaker, what's your threshold for that. So these are really important things before you sign. We've had people send us contracts that they've already signed, and it's much more difficult to go backward. In fact, probably not likely. And you end up having resentment before you've spent very much time there at all.
I'd like to add one thing about the idea of signing a contract. There is this rule of law called the Peril, looks like Peril evidence rule. And it basically says that if two parties are in negotiations to build up a contract, and there's all kinds of promises that are made in the meantime, if those promises, are not within that written contract, and most written contracts say this is the full contract and this is the deal, nothing else is the deal, you can't even bring up the evidence that they promised you verbally. That, for example, if we just lay you off, of course we're not going to enforce this. So if they don't write that down and modify the agreement, it is worthless. It is not.
We're getting that right now with COVID, Joe. We've had midwives getting less hours and they want to quit and go work somewhere else, or they're not working at all, but they still are held to their contracts.
Yeah. Whatever we call it the four corners of the contract, as if it was a one-page document. Whatever that says is the whole deal. Imagine buying a car and the dealership tells you it's going to get 300 miles a gallon. It's going to get you laid. It's going to get you whatever that car promise is. But in the end, what you get is a Ford Focus that's in 2010 with 300,000 miles on it as is. And you walk out, you've signed that, and none of the other things happen. All you have is that original, what is in the paperwork deal. And that's so important because there's so much of a trust. There's a romance period. There's a courtship that goes on as we move through these kinds of things. And often, you're trying to demonstrate that you appreciate them and they appreciate you. But if these contracts aren't modified to include those kinds of serious considerations that are important to you, may not sound important to the other side, it ain't there.
So on these references, I want to just point out a couple things you might be interested in. The 50 state non-compete laws is on this fair competition online resource by the law firm of Russell Beck out of Boston, Massachusetts. He's actually noted by the Federal Trade Commission as one of the foremost authorities on non-competes nationwide. And he has a very up-to-date, readable website by state on everything you want to know about non-compete laws.
And what I would suggest, if you use one of these 50 state or 54 state, depending on how they do territories in DC, is look at what they have to say but then the good ones, and this one is definitely one of them that is good. They will give you the citation to the local law, and go back and look at that, because you may have a citation where the person who built the charge said non-competes are not enforceable against healthcare providers. But what you have to find out is a midwife a healthcare provider under that conversation? So you can't just take a helicopter view of these 50 state surveys and trust them. Sorry.
No, that's okay. The next thing is the Federal Trade Commission full transcript, which is 100 or more pages of the current debate on the Hill about policy, a potential policy change on removing non-competes. Pretty fascinating. The Texas 12th Court of Appeals midwife case, we were very careful to make sure we use public-facing documents. So if you're interested in learning more about that case, easily retrievable. And the AMA statement on non-competes is also there, as well as a survey by the nurse anesthetist. So we just sort of wanted to let you know the body of the literature that we pulled. Just a short an acknowledgement of what we're doing at Grow Midwives. Some people still are learning. We do a lot of contract reviews. We're probably over 250 since we started a couple years ago. I do resume reviews, career coaching, whether that's prepping for an initial interview, prepping to negotiate a contract, and also work directly with midwifery groups who want to, as a collective, approach negotiation for work and salary conditions. We do practice retreats and strategic visioning that have been fun and very successful pre-COVID when I could come on site. We work with hospitals and physician groups interested in midwifery-led care to create best model practices. Sometimes that's more in depth than others, but it is a service line that's growing. We are currently consulting for 2 new midwifery education programs in the US, and we try to do a lot of free education to be useful in ways that don't require any kind of fee for service. So in return, what we would ask you, we've been doing a few webinars this year, is if you like what we're doing, we would love your feedback, and we would love it to be public if you're willing to do that on a variety of social media outlets. So I'm going to move now to the Q&A period. And Joe and I have got a full half hour. If there are questions, we would love for you to ask them. If you're willing to turn your video on, we love seeing people. And we'll just sort of wait and see if any questions pop up. I know sometimes people are more shy than others, or maybe you have some. So let's go. Catherine.
So my question is, right now I don't have a contract, but some of the other midwives in my practice do. And I go back and forth between thinking they have it better or I have it better. But I think if I were to get one offered to me, it would have a non-compete in it. Do I have any latitude to just say, I'll sign it, but you have to take that part out entirely? Because I think what they've done to some of the others is just said, well, that's just how all our contracts are. But they have also said in the contract, 40 hours is 1.0 FTE. And then they've told the others verbally, oh, but for the midwives, it's actually 48 hours. So I am hearing you saying that they could just drop back to 40 hours a week, and the 8 hours thing in this case, instead of being a promise that they made to us, it's a promise they made to themselves that would not be enforceable. So I guess I had 2 questions there.
Yeah. Ginger, you want to stop the share screen and maybe go to the Brady Bunch view?
Yeah, I can do that while you're talking.
Or Hollywood Squares.
We wanted to show our grandson for just a moment.
Yeah, as is the world's cutest person. Let me build your question this way. I can't speak to, lawyers always have to issue these nonsense disclaimers. I can't speak to your situation, but in general, here's the deal. You're still sharing your screen.
I know, Joe. I'm trying to. It's hard to get it to prompt out. Just keep talking.
These contracts, they are all generally you just got a job and you're an at-will employee, meaning that you can walk away from working for them and they can walk away from you. They can fire you at any time you want. So most of what an employment contract gives you are safeguards for the employer.
Yeah.
There are page after page of ways in which the employer becomes protected, and basically all you get out of it was the job you had in the first place. They almost always they always include some kind of at-will employment termination, meaning either one of you can walk away, but the difference that the contract offers is both of you are bound to give somebody at least 60 or 90 days notice. So in our estimation, as much as we're out there marketing, doing employee contracts, the only time you see employment contracts being themselves something of tremendous value would be in the entertainment or sports industry, where we're going to guarantee you we're going to pay you $10 million over the next 10 years unless you do these 10 deadly things. And so you have a contract right to have employment and income from the contract. This at-will situation doesn't give you that. So if they come to you and they say, we want you to engage in this contract, you're within your rights to say, what are you going to give me for that? Because right now I'm under no restrictions in our relationship and we've been getting along fine. I want to know, what more are you going to give me? And frankly, it should be fairly substantial. If you're making $100,000, maybe depending upon your marketplace, would it be 150? If you want more CME, if you want more time off, you want to be treated better on the schedule, those sorts of considerations that are all part of the employment relationship. Maybe more of you get incentivized by more deliveries you make, of that kind of thing. You don't mind working, but you just hate working more for free. So that would be kind of the situation you're presented with. And when an employer comes to a standing employee and says that we want you to sign a non-compete, that presupposes that they think that you are a danger to them of taking what you've built in your professional career, working with them, and transplanting it somewhere else. And so that's where we go back to that consideration thing. You should not anticipate that just continued employment is an appropriate consideration for signing that contract, because they're already afraid you're going to quit. They're already afraid you're going to move across the street. You have them over the barrel. And the kinder way to say that is, I talked to my lawyer, and my lawyer tells me that if there isn't any additional consideration, and you're just asking me to sign a non-compete just because it's fun to sign, it's probably not going to be enforceable. So we're all whistling in the wind here, and working with somebody to fine tune that conversation would be really helpful. But
the physician or the practice manager, who's often the one midwives are negotiating with, doesn't have a clue. They don't have a clue.
Or are unhinged because they have a momentary problem in an economic crisis. What we're seeing a lot is a lot of these practices, because of COVID, are in incredible economic stress.
We all had 15% pay cuts for 5 pay periods, with no guarantee that we would ever get any of that money paid back at a later time. And our practice manager actually tried to bump our hours down, because we already work 48 hours a week, not 40 that we're supposed to if we were any other kind of NP. And she was told that we can't, we're losing too much money. They have to keep all their clinic shifts. So.
Yeah. And so if they turn around and offer you a contract that even further restricts your rights, they're flipping nuts. They're telling you, we have to have you. We have to ask you to at least keep the production level as you are. Otherwise, this is not going to work. Now, they're going to say things like, well, we'll just get rid of y'all and come up with a new model. Well, they could have done that last week.
Yeah.
If it was that easy. So, you know, the negotiations are very different than what a bully might let you believe. And by the way, there are bullies in all professions.
Okay, well, thank you.
Yeah.
Other questions?
I have a question.
Yes.
Go for it.
My name is Allison. I don't have my video on because it's COVID and I'm in my pajamas.
It's fine. It's fine.
I won't tell you what I'm wearing below.
Yeah. I really want to thank you guys. I mean, this is amazing. And I'm so glad that you provide these free webinars. I've just gained so much knowledge. My friend actually just sent this to me on Instagram like a couple of days ago and I signed up. So I'm excited to share with everyone I know. My comment is, what was interesting is I was a new graduate last year and I signed a non-compete. They had just started it with me. I was the first provider that they started it with. And it was word for word example number 3 that you had on the slide. And I saw that and I was like, oh my gosh. So, you know, I work at 4 different offices in a hospital and it locks me out of 15 miles of each of those locations. So I'm basically locked out of 3 cities. So if I wanted to move jobs, I would have to pretty much move states or, and it's for 2 years. So my question is, I guess there was some confusion. The 2 years, is that saying like if I stop working there, then for 2 years I can't work anywhere else in that area? Or is it saying that I have to work for this employer for 2 years for that not to count, I guess? I think it's the first one, but I had my family was saying, is it not the second one? I don't know.
Without reading the agreement and relying on what we see all the time, reading the agreement, there are other provisions that float around inside these contracts that affect this one clause. It is going to be after you've terminated your employment. That's when the 2-year clock starts.
That's what I thought.
Yeah. Often these agreements have provisions somewhere in them that if they think you breached the agreement, then the 2 years doesn't start until after we solve that problem. Now, this brings up an interesting issue though. Some employers include things like non-competes and other provisions for post-employment restrictions to have leverage so that when they choose to part company with this employee, they wind up saying, well, we're laying you off and we just can't afford to do business anymore. And if you sign this agreement not to sue us for all the various things you could have sued us, including sometimes very scary sexual harassment, those sorts of things. But any claim you have, you're going to give up all those. You're going to promise to talk nice about us, and we'll let you out of the non-compete. So as you depart from an employment relationship, you may wind up with opportunities to negotiate your way out of the non-compete. And strategically, some bright people have put in non-competes without any real concern over competition, but to use it as leverage to get people to give up on any claims and lawsuits they may have when an employment relationship goes down the tube.
We've seen some of those non-disparagement clauses.
One of our best friends was kicked out of a midwifery practice, and when they were kicked out, all the conversations circled around to, we'll bury the hatchet and we're not going to enforce the non-compete if you'll promise not to sue us for anything.
Wow.
So sometimes it's bait.
Thank you for the information.
Yeah, it may really be important in your circumstance. It's interesting they just started the non-competes, which leads you to believe that competition by midwives who have left the practice and somehow destroyed the value of the current practice may never have been a big idea.
Well, they also had just started, this practice signed on with an alliance of other practices, and the new HR for the umbrella alliance is the one that enforces all the non-competes. And I was the first new provider hired under the new like HR or whatever. And as a new graduate, I was like, you know, desperate for a job. And I was like, whatever, I'll just sign the contract. You know, now looking back, I'm like, I wish I argued that.
Well, and you can't do the retrospective scope thing. You know, you did what you did. And early in your career, it's less damaging than if you have a 20-year run in a community. But that brings up to mind another issue, and that is back to our outline in the slides. Why do you want this non-compete? And the person you may be talking to is the person or people who own and run the practice. And we're seeing all the time all kinds of trouble caused by practice managers or people who may have limited abilities and education that are running a practice, and they're starting to set all these rules up. And let's say it's a one doc practice that is hiring these midwives. This doc may have no idea that, like Ellen DeGeneres claims, that everybody's running amok around her and creating all this hostile work environment, and they don't intend to have that happen at all. So raising the issue to the decision maker instead of these intermediaries would be a negotiation issue of some merit.
Yeah, we always try to stress, find the physician champion if you are meeting resistance with an office manager or HR department. Other questions?
So following on to what Allison was asking, I am a student midwife currently, not set to graduate for a little bit. So going into that landscape is very different because you are just desperate to get that first position. And so you almost feel handcuffed. What pieces of advice, where do I start when I'm looking at these non-competes?
I would look at interest-based negotiation theory, like getting the yes and some of the other kind of ideas on how to negotiate things. And you may find yourself in a situation because you're low on experience and high on interest. And you really, the idea of simply being employed, which has to do with career development, which is a monetary value that is beyond measure, plus having a job, because God only knows, you might have one student loan or two, and other issues along those lines. You may find yourself more than willing to say, I'm going to go to work for this group. I have a 2-year contract, and you know, I'm going to be careful to watch how it auto renews, and I'm going to rent someplace in a 2-year lease, and you know, hope to God that I don't find true love and have a kid or two in the meantime.
Yeah, that ship has long sailed. I'm a grandparent, so I own the house. I have the kids. You know, this is the second career.
I would say, Amanda, that some of those 10 points that we talked about, how to negotiate, you really need to practice those.
Okay.
And when I work with people on getting ready to negotiate a contract, we talk about the specific wants and needs. What do you really want? And that could be the moon and the stars. And what do you really need, which is the floor. Will you never move out of your community? And if that's the floor, and there are non-compete elements that make it very difficult for you, maybe you can negotiate the time in it. Maybe you can negotiate the geographic region. Maybe you can negotiate, I won't go work for these 5 competing practices. But some negotiation is required in any employment agreement, because if you just go say, hey, I want the job and you don't even tell me how much I'm going to get paid, you will not get nearly what you should get, and they will take wide advantage of you from that day forward. You may not have access to revenue generation that you bring in. You might not have access to decision making for the practice, at least your opinion, because you've now been labeled as someone who just simply has to have a job, and your desperation it translates in ways that I think a lot of midwives don't understand. So please find something to negotiate. There's a contract that Joe and I have reviewed where there hasn't been one thing that either on the legal side or the professional side that we haven't said, try to negotiate this.
Okay.
And if you all find that contract, we want to see it.
Ginger, you might speak to the utter profitability of hiring a midwife. We're seeing midwives sign on with annual salaries between $80,000 and $150,000. These employers are out there. What are they buying for that $80,000 to $150,000 a year?
Yeah, a lot of times an agreement that says, this is what you're going to work, but we can change that at any point in time, which one of the other midwives said has happened to her practice, where they got cut in salary but had to work more hours. At their discretion for patient needs, they can modify your schedule, which is why it's really important that you negotiate high and come down in that process. There are lots of ways that midwives are getting additional supplemental funds through quality metrics, through RVU productivity, through income generation over cost. All those are analytic methods for additional bonuses beyond the salary. And maybe that's not in the agreement. Well, let's talk about that, because I promise you, every physician has a bonus model, and most nurse practitioners do. So I'm not sure if that's what you wanted to hear, Joe, but
you got to see.
What was your question?
You hire somebody at $100,000 a year. It probably costs you about $150 to keep them employed. By the time you have all these,
what's the midwife's profit margin?
Yes.
If they're full-time, full scope,
yeah, there you go.
obstetrics, gynecology, maybe first assist, not necessarily, but procedures, you're doing some. The data that comes out of Pacific Business Group on Health and the performance that we've done for people outside of California, you are making about $800,000 to $1 million per midwife per year. The costs for them to employ you with an overhead of 50 to 60%, which is the overhead most physicians' formulas will outline. Your malpractice, your CE and all of that, calculated in the end, after expenses, you are still profiting them around $300,000 to $400,000 a year. Proven. So you need to go prepared understanding that, which they may or may not know. You're the first one, they're not going to know that. But that's how you sell yourself at a higher salary or a bonus structure of some sort.
You woke up Catherine.
The question also.
I'm cooking
And,
dinner too, so I had to shut it off for a little bit and just listen.
Yeah.
I think, was there somebody else who had a question before we jump over there, Catherine?
Can you hear me?
Yeah.
Okay. So we were faced with a little bit of a different situation where we work at. And for the last 5 years, we've been a team of 4 midwives. Currently, as of July 1st, we're down to 3 midwives. And now 1 has resigned, which will take us down to 2 midwives. So that's our background history in the last almost 2 months. So with the loss of the first midwife, we were given new contracts. And for almost 5 years, we have not had a non-compete clause. So now we have one in our new contracts. Basically, it highlights 30 road miles for 1 year. But in our situation, we also see patients in 2 different locations, which are about 20 miles apart. So that clause stands for both offices, correct?
Again, back to that individual advice, and I don't want to stand in and interpret your individual contract for you, but probably what you need to do is talk to local counsel who understands these kind of contract terms and figure out how enforceable your contract is when you have, when you have one of these situations where really the consideration for you signing the non-compete was to keep your job. Unless they gave you a lot extra.
Krista, did they give you anything or just say you had to sign it?
They've taken away a lot. And I was going to ask you about that too, even though it's a little off topic, but it also says now it's worded that we should work a minimum of 40 hours. Well, I mean, 80 hours is a minimum of 40, you know, so that's, I feel like it's very dangerous terminology, as well as our on-call hours are no longer going to be counted in those 40 hours. Our on-call time is going to be a separate bank of hours where we're expected to work a third of the call.
Are you going to open that birth center?
We've had our birth center open, but yeah.
I'm just giving you a hard time. You know, I care deeply.
I think that if you employed local counsel, one of the first things that they would enter into a conversation with your employer is it's pretty well settled and is a big black mark on the compensation portion if somebody turns around and adds non-competes midstream in an employment relationship, and especially if they didn't give you additional consideration. So instead of being a minimum 40 hours, maybe it's a minimum 30, or maybe you got 25 or 30% raise, or you suddenly became world's greatest midwives instead of just midwives as far as job description. Whatever it was, you should have been paid something other than the threat of being fired.
I think they're trying to take advantage of Krista and her partner, thinking that they're not going to seek legal advice, that they won't understand, and that they're going to lose their job if they don't sign it.
Right.
I can add in that we have gotten advice, and we went back with negotiation, to which we were met with no terms will be changed, absolutely no negotiation. So, I have my decision made. I'm just kind of.
So have you signed this agreement or not?
I'm not going to sign this.
Yeah.
So now I'm kind of looking at my next step. I mean, I don't know if they'll say, well, then you just stay without a contract. Or if they'll say you've got 90 days and you need to leave.
Of all the things I've learned in practicing law for about a quarter century is that people who are aggressive, bullies, people who say this is the deal or nothing else, but still thrive to keep that working relationship, they're bluffing. Threats are not something I tend to market in. Because I believe that if there's a direct downside on the relationship, that they're willing to forfeit anything to get their way, they would have they're either going to do that or would have fired you before, because you could have been fired this morning. And so no is a perfectly good answer. And then they're left with, as you just learned from Ginger, how the hell are they going to serve their patients, not get sued by their patients, and have these worker bees generate an income? What they're trying to do is preserve the empire they have currently by threatening to burn it down
With less people.
And the benefit is that in my current contract that's still binding, I don't have a non-compete.
There you go.
Right. Yeah, I would be so brash as to say, I'm not willing to sign a non-compete at all because I'm ensconced in this community, or I would only be willing to sign a non-compete for some ridiculous price, $100,000, whatever. And then that non-compete not be effective. And if you fire me, because here's the setup that concerns me, I get you to sign the non-compete employment agreement. And I've been sick of you forever, but I bullied you into signing that non-compete. Then, okay, we have a brand new contract with a non-compete in. The way most of these contracts work, I now can give you 60 days notice 2 minutes after you sign the agreement, and you're now involved in the non-compete for no value at all.
For 2 years.
That they can just
A year, whatever.
You committed suicide, effectively.
Right.
Ask him if he would sign something like that, understanding what you understand.
Yeah.
That's always my favorite question. If it appears to be an unfair, almost bullying measure, turn the question around and say, this is how I understand what's happening to me. Can you help me understand if you would agree to something like that?
Right.
Yeah, you're in a situation that's effectively some
And
kind
you've been there a while, Krista.
Yeah, almost 5 years.
Yeah.
So
Well, we have time for probably one more question. And then if you have a couple questions and you want to email us, you can send them through the contact form on our website and we'll respond to you. But let's take one more question. Is there another one out there? Are you all feeling okay?
Bueller.
Catherine, did you have another question? You're on mute.
I'm just still puzzling over how much money we apparently make, because I feel like we get told constantly, oh, the prenatal clinic loses money, and sort of, I mean, I feel like we get told all the time that we're sort of like worthless in terms of making money. So I'm very interested to know, are you putting up information about the money
You
piece
can.
that we're talking about? Like, is that in the references?
No, it is. I can send you to the website. The Pacific Business Group on Health
Okay.
has a financial pro forma done by Millman, who's internationally known finance accounting firm, with California data for midwives. And so when we do these projects for midwives not in California, we have the midwives gather a variety of data points. What's the global OB? What's your annual number of GYNs? What's the level of complexity? How many patients do you see in 4 or 5 categories? You'll see it on that document. And you begin to plug in those numbers by the number of encounters you do, and you will get an annualized report of revenue generated. The number of births you do, and some of this is dependent on whether the physicians are billing incident to, so they're getting they're capturing the full amount of the payer, or if you are, say in Kansas, billing under my name, getting 75% of the fee.
I always like that. We get 85% of what the doctors get for providing great outcomes.
Yeah, but maybe you have assigned in your contract, which most of them do, that they get to bill for all of your services, which means they're billing physician fees.
Well, I mean, we work for a hospital that's a mix, so I feel like I'm also totally blind to all of that stuff.
Yeah.
And I know they're trying to make the physicians are salaried, and they're trying to get them to go on RVUs, and I'm worrying that they'll make us do it. I actually appreciate just having a salary, and I wouldn't care if the doctors just got RVUs, because I think once everybody is on RVUs, then you start bickering and fighting over who does deliveries, and
that's exactly what happens.
It's not my jam.
Yeah.
Well, and whether a particular practice is profitable or not involves so many other variables. I mean, we're in an era where there are these cathedrals that are made to offer medical practice care, and you have a valet, you have all these things that come up that are costs for the business, that are legitimate business expenses, which might even include a CEO or a CFO who make ridiculous amounts of money. And all those go into the overall profit margin on whether your clinic is making money.
Mhm.
So you may have one physician who's the kingpin of the physician get an extra $200,000 or $300,000 just because they're the kingpin, plus their regular salary. Gee whiz, now we're losing money. The metrics that Ginger's talking about would be the rational expectation on return on investment under normalized business expenses. So, just because the clinic is not making money for one reason or another doesn't mean that the midwifery services being offered aren't extraordinarily profitable, and that's how they got to that nominal loss instead of an extreme loss. It's you see that in the entertainment business, where artists are offered a share of the profits only to find out that Star Wars never made a dime. That kind of thing. So you got to get into the nuts and bolts of it to figure out if there's a value there.
I'm putting in the chat box the website. It's pretty easy to find if you just type in Pacific Business Group on health, but it'll be in the recording now as well for people who might listen later. Well, we're going to say thank you again and good night. And I'm not sure what we'll come back with in a month or so, but we're going to continue these opportunities to explore the business side of advancing and sustaining our profession. So thank you so much.
Thank you.
Thanks.
Thank you.
Bye, everyone.